Hi everyone. This month the data protection regulations came into force and there is no better person, or I can't think of a single person in this Kenyan jurisdiction, better place to discuss with us the data protection regulations, what they mean for us, than my own partner, Shem Otanga. Shem, welcome to the podcast.
Thank you very much. Thanks for having me.
I'm really excited to have you here. I'm excited that you
Happy to be here. Yeah.
You are.
Yeah. It's been a while.
It has been a while since you were on the first podcast.
First podcast, I think I may have been on another one as well with Ife.
Oh,
Google.
yeah.
Very briefly though,
Oh,
I didn't
yeah. So you
contribute
have
too much
contributed a lot to the podcast. So thank you so much.
No worries.
So Shem is our tech partner. What do you call yourself? Is it tech?
So I oversee the TMT department, but mostly IP and data protection. Together with yourself, of course, you do the corporate deals in TMT and our partners in South Africa as well.
Yeah. So really, you're the expert on this subject, and I think it's important for us to understand the context. First of all, why is data protection something that people are talking about? Why is it important in this day and age?
Well, that's a good question. It's really where everything begins.
Yeah.
Data protection is premised on a fundamental right and freedom under the Constitution.
Yeah.
A human right, so to speak, the right to privacy. Traditionally, the right to privacy in Kenya under the old constitution did not go beyond the right to, not having one's property searched. So it didn't go as far as speaking to your individual rights to privacy as a natural person, right?
Yeah.
So it only spoke of your property, and it wasn't as broad as what we have now. So with the adoption or the promulgation of the current constitution in 2010, a more broad and purposive provision came into force. A very wide provision that says the right to privacy includes. So it doesn't just set out what the right to privacy is. It says this is a broad right and it includes the following. It may have a lot more.
Yeah.
And one of the items cited there is the right not to have the privacy of one's communications infringed, or the right to privacy of one's family affairs and all that. So the Data Protection Act was passed to give life to that constitutional right.
Yeah.
Now you're well aware constitutional rights have a heavier sort of weight in law.
In terms of infringement.
Absolutely, and really. Just in terms of the hierarchy of laws, right? So it's the basis. It's what I don't want to use Latin terms, but Grundnorm in Kensinian dictum.
I love it.
As my former constitutional law professor used to say, Professor Githum Igai. So it's a constitutional issue. It's not just a statutory issue. It's your personal human right. It's your fundamental right under the Constitution to have certain pieces of information about you treated in a particular way that respects your right to privacy. And aside from that, because of the digital world that we live in today, if certain kinds of information fall into the wrong hands, a lot of harm could actually occur, right?
Yeah.
Right? If your financial information fell into the wrong hands, a lot of economic damage could be visited upon you. If certain login details or access to your emails was obtained by unauthorized persons, they could communicate on your behalf without your knowledge.
Yeah.
All manner of things could happen that actually prejudice you to no small degree.
Yeah.
So it's important that certain kinds of information be treated with a certain kind of protection, which is not the subject of regulation.
Yeah.
Yeah. So to my mind, that's why this area of law is very important.
So I think most people will say that it has emanated from a European or US concept of data privacy. I mean, even the word is not a fundamentally word that's used in an African context. What is data?
Right.
It's very of the digital age. That's what I mean.
I mean, you're right. It's not a historically African legal concept.
Yeah.
You know what I mean? Okay, our legal systems are borrowed anyways from Europe. But even post-independence up until 2010, these concepts are not really known to us.
Yeah.
Or codified within our.
But they were also not known to Europeans or even in the States. I mean, the GDPR only came into force, isn't it, in 2010?
In 2018 is when it was implemented.
Worse than that, later
But
than that. Then.
There was a directive before then.
Yeah.
So it was just a development of existing rights and regulations in these jurisdictions. I mean, the US is still in the process, I believe, of trying to get an overarching law.
Yeah.
So different states are legislating on this subject as we speak. So Europe basically has been on the cutting edge, so to speak, or the leader in terms of the development of privacy regulations.
Yeah.
And I guess the GDPR is considered the quote-unquote gold standard just because of how comprehensive it is. And
I mean, it's a huge document.
It is a huge document. It's very comprehensive. And no wonder a lot of jurisdictions across the world are borrowing from its provisions and looking at it as the best practice, so to speak, from international perspective.
So I guess my question in that context is, since Europe has only recently enacted the GDPR, we have now gotten our own act in Kenya. Africa, I don't know, but you will give us that information. Is it necessary in this jurisdiction yet? Have we come to the stage where it's something that is required to be protected, even though as you say, it's a constitutional right?
I think it's overdue. This sort of regulation is overdue because, as you're well aware, the whole world is beginning to leverage, not beginning, or has been leveraging on technology and the digital world, to advance literally every area of human life. To be fair, government operations are being digitized the world over, including here. Private entities are leveraging more and more on technology to sort of give a competitive edge to their businesses. You can't really operate outside of the digital space anymore and be competitive or relevant, regardless of whether you're in the private or public sector. People want service delivery to be at their fingertips. So with the increased reliance on technology and digital infrastructure and such frameworks, it's important for us to have these sorts of laws. Yeah. It's critical to have this infrastructure in place to support the sort of tools for public service delivery and commerce and public and private sector enterprise. Yeah. And just instills confidence in the public, to be fair.
Okay, so let's talk about Africa. And have other countries in Africa enacted their own data protection regulation? How far behind are we, or how advanced are we in terms of that?
It's been happening quite a bit. Not all African countries, but I haven't counted, but I wouldn't be surprised if upwards of half of African countries do have some form of legislation in the data protection space. Mauritius, South Africa, Uganda, Nigeria, Ghana, and the like, and Kenya, of course. So this sort of legislation started happening around about, I would say, 2012, when, for example, Ghana had...
2012 is ahead of time, right?
Yeah, but the conversation was happening. Remember, we had a provision on privacy in the Constitution in 2010.
Correct.
Right? So 2012, Ghana, enacted their law. In 2013, South Africa adopted POPIA, but had a very long grace period, which I think was good to sort of give guys the opportunity to familiarize themselves with the law and acclimatize. I'm not sure how well, players in that country, worked on their, preparedness for the commencement date. But it came into force, I believe, in 2021 or 2020, one of the two. I forget exactly which one. I think 2020, I'm not sure. But they had a long grace period, that's the point. Then, of course, then came countries in East Africa such as ourselves in 2019 and Uganda as well. Tanzania, to my knowledge, does not have a law yet. So it's still an ongoing process in a lot of these countries. But there's been seriousness about implementing the law. The South African regulator, for example, has been very active about, making sure this is a practical piece of legislation and not just something on paper. Yeah. Uganda and Kenya as well have passed regulations. Ghana has a regulator in place. They've had one for a while. I mean, it's not a theoretical thing. And I think a lot of players, a lot of people are waking up and smelling the coffee and saying, hey, listen, this actually matters.
Yeah. So have we had examples in Kenya of data breaches, or do we have jurisprudence already on this topic ahead of the regulations?
So the data breaches happening everywhere, including as we speak in Kenya. I'm sure people are breaching data even right now somewhere. But in terms of jurisprudence and decided case law in the High Court, that is reported, that is still coming out. The High Court has, of course, pronounced on various issues arising from the Data Protection Act in various contexts, primarily, the Huduma number context. Where the High Court, gave a very interesting ruling, giving retrospective effect to the Data Protection Act as far back as 2010. We wrote on that a while ago. And so that has been the context in which we've had litigation in court, right? But there have been claims and complaints lodged to the ODPC, the most prominent of which I recall sometime last year, where a leading, hotel franchise, local hotel franchise. Actually, it's a global one, but they've got a local presence. Had an incident where their guest register was leaked onto social media, and people whose names appeared on that register felt uncomfortable.
I mean, it could be quite embarrassing,
Exactly, because now people know that I was at this hotel
and with someone or with whatever.
Those details didn't come out, but I mean, you don't want people to know where you are. I mean, certainly not the whole world, which is exactly what happened because this was on social media. So lawyers were instructed, a complaint was lodged, and this was before the regulations came into place, the general regulations and the Data Protection Act. So not quite sure how that was processed because it's not a public a process, at least it wasn't at that time. And no sanctions as far as I know, were visited upon the data controller in that context. So there have been scattered complaints here and there, including yesterday we saw one also on social media.
That was an employer-employee situation.
Right, in an employer-employee context. So just to sort of underscore the point I made earlier, there's lots of breach happening. Awareness levels are fairly low. And a lot of work needs to be done on that front, and we do a lot of that, including this podcast. On this podcast, to try and sort of educate people on the need to comply, because the law applies. It's a cross-cutting piece of legislation. It's like a tax legislation or tax law. It cuts across all sectors. Okay,
so let's do just that and educate the people.
Right.
So the regulations were enacted in January, so 14th of January.
They were gazetted on 14th,
Gazetted on the 14th of January, with the effect that they would be in force, or compliance would have to be in place by the 14th of July. Explain the confusion with that and why it is that there's a requirement to comply now, as opposed to a deadline that was set on the 14th
Right,
of July.
So, just to be very clear, there are three sets of regulations. So we had the general regulations, then we had complaints handling and enforcement mechanisms regulations, and then we had now the data protection, data controllers and data processors registration.
Okay. So data controllers and data processors were meant to be registered by the 14th of July under the regulations.
Right. So it was gazetted in January 14th with a 6-month grace period.
Okay.
Right. So essentially, it's the provision says that these regulations will come into force within 6 months from the date of their gazettement. Or come into effect. So the date of effect was 2 weeks ago, on 14th of July. So the data commissioner launched the website and the infrastructure for submitting applications on the 14th.
Okay.
So no one could file an application.
Okay. So no one could be registered prior to 14th of July.
Exactly. So the first application was submitted on that day. Credit to the data commissioner for setting up, a very good platform and having it up and running on the day when the regulations came into effect.
Okay.
But one could argue that it may have been, better to, set up a platform so that people are registered.
By the 14th. Okay. So that's, I think, where the confusion was. Could people be registered by the 14th, or was it a deadline? Or were they just supposed to be starting the process of registration on the 14th? Yeah, and I think that's what it is now.
Exactly. So it wasn't a deadline, it was a commencement date or a date of effect, and the data commissioner set up the mechanisms, and people submitted applications
All right.
as from 2 weeks ago.
Okay.
So that's what happened there.
Okay, so let's go into now the regulations themselves. The first
Right.
thing that you talked about is complaints handling. So under the regulations, there's a process for handling a complaint for a breach of data protection legislation, correct?
Right. So that's under the complaints regulation.
So yeah, so there's a complaints
Which-
regulation dealing with how complaints are handled.
Yes. So
Then there's-
forms and filings and all that.
Correct. Then what is the second one that you talked about? You said there are three.
So there's the general regulations which basically provide for everything from how to handle data protection impact assessments to how to go about making notifications to the registrar, to the commissioner, in instances of breach
Yeah.
of personal data, and a raft of other things. So there's a general set of
There's a
regulations,
general,
but
so
then
there's
this,
the complaints handling, the general, and now the registration of data controllers and data processors.
which has just
What
come.
are those? What are the? What is a data controller and what is a data processor?
So data controller is basically what the definition the Act gives.
Yeah.
Is that this is a person, right? It could be a private person, it could be a corporate entity, it could be a public body, that determines the means and purpose, right, for processing personal data. So if you come up with a project and you say, hey, listen, we're going to need to collect people's information for purposes of this project, and you define what the purpose is, and you engage directly with the data subject and you ask them for data, you are the data controller, right? You determine, for example, we're going to collect this through USSD codes, or we're going to have a platform where people key in their information. You are the data controller. You determine the purpose and the means
Okay.
for processing of this personal data.
Yeah.
And processing basically means handling
Yeah.
the personal data. So a lot of people fall in that category, right? And that's a data controller. A data processor is any entity then that processes personal data on behalf of the controller.
Okay.
So if, for example, you outsourced or you've contracted someone to store your personal data on your behalf,
Yeah.
perhaps a data center that has got certain sorts of infrastructure that provides added levels of security, they would be a data processor.
Okay.
They're not in touch with the data subject. They didn't determine the purpose for which you collected this data, etc.
Okay.
So there's that distinction.
So let's talk about a normal business
Right.
in Nairobi, mid-sized business, 50 to 100 employees, let's say in the manufacturing industry. Do they have to be registered as a data controller and a data processor?
You're right. That's the crux of it all, really. Because the Act says first of all, prohibits any person from processing personal data. Controllers rather than processors from processing personal data without first being registered
Okay.
with the data commission.
Okay.
Then the regulations sort of now set the threshold
Okay.
for who is exempt and who isn't.
Okay.
It's very wide. Very few people are exempt. So you're only exempt if you've got less than 10 employees
Less than 10.
and if your turnover or revenue is less than 5 million shillings,
Okay.
right? So lots of
So
people-
it's an and, not an or.
it's an and. So you've got to meet both criteria
Correct. Okay.
in order to avail the exemption to yourself.
Okay.
Now there's a drafting error in the regulations that then disapplies the exemption,
Okay.
and therefore it means everyone on earth should register. But it's a drafting error.
Is it a drafting error that they've acknowledged is a drafting error or not?
No. I mean, who will acknowledge it? You just leave it there until someone amends it. But the import of this is that, out of an abundance of caution, the most lawyers, and understandably so, are advising all data controllers and data processors to register
Okay.
with the commissioner. However, the commissioner's approach practically in the registration of controllers and processors gives effect to that exemption,
Okay.
despite the existence of a provision disapplying the exemption.
I mean,
Don't say too much.
Not
Let
great.
me not comment about the drafting,
Okay.
but these things happen.
all right.
It's a
not
very
great.
big gap, I would say. So they need to amend that.
Okay. So now, in terms of registration, what is the cost or impact to businesses? Is this something that people can manage to accommodate for in their budgets?
Absolutely. But before I get to that, let me just add on in terms of exemptions, a very important rider that this exemption would not apply to people who process personal data for certain purposes
Okay.
that are set out in the schedule to the regulations. So if you're in the banking business, for example, financial institutions, in the healthcare space, if you're in the gambling space, if you're in direct marketing, if you offer transportation services, you're hailing app services and all that, you would need to register regardless of whether you meet the threshold for exemption.
Because, I mean, those are specific categories
Exactly.
of businesses.
So people in those sectors, a number of which are regulated, really just need to flat out
comply
with the registration requirements. So, but then on to your other point about what sort of cost implication there is, I mean, the government fees range between 4,000 Kenyan shillings to 40,000 Kenyan shillings for registration of either data processors or data controllers. And if you occupy both roles, you would have to submit two separate applications, one as a data processor and one as a data controller.
So we're talking about a total of 80K?
Yeah, that's on the higher end.
Okay.
Right? So between 4,000 and 40,000. And that may not be a prohibitive cost considering that the registration lasts for 2 years.
Oh, it's a 2-year registration.
Right, it's a 2-year registration. And it's scaled based on turnover and number of employees, so they've considered the size of the organization. Certain bodies like charitable bodies or not-for-profits and stuff like that, religious organizations, just pay 4,000 shillings, regardless of what their turnover.
Okay. So they've even considered the type of business that you're doing.
Exactly. So they've tried to make this something that will not be a big burden to businesses. The idea is not to create more barriers to entry and setting up and all that. We want our ease of doing business index rating to be as high as it possibly could be.
Yeah.
So the idea is not to introduce bottlenecks and unnecessary requirements that just drive up the cost of doing business.
So currently we are doing applications, and we're doing applications for digital credit providers to get licensed, and that licensing application is extremely complex, long, and the requirements are many.
Indeed.
Yeah. So what is it? Is that the same with here, or is it much more simplified?
Not at all. The process has been simplified, thankfully, because this is a very wide, cross-cutting piece of legislation. You don't want to make it so onerous. Digital credit providers are, specific to one sector, right?
Yeah,
the banking sector. They have one regulator. Not everyone operates in that space.
Yeah.
This is a law that everyone has to comply with. You can't make it very, very complicated. So the process is online. I mean, there's an e-portal on the ODPC's website where you create an account. You fill in your basic details, name, address, contact details. Then you provide details regarding the number of employees that you have. You provide details regarding your turnover or revenues. You provide additional documents like your audited financial statements. And then most importantly, you then give a classification of the personal data that you handle. So you've got to set out all the personal data that you deal with and all the sensitive personal data that you deal with.
Yeah.
So this requires that you actually have an internal audit and just have a look at what you actually manage your process.
What is sensitive data?
So it's a category of personal data that's accorded a high level of protection because of its sensitive nature.
And what is that?
Information regarding your spouse, your children, your property details, your sexual orientation, your health status.
Yeah.
It's not like your name or email address. You don't want people to know if you're suffering, say, from particular disease or things like those, or if you've got a particular condition. Not that there's any stigma around that, but it's more personal. It's more sensitive.
A considered public stigma, whatever.
Exactly. So for those sorts of personal data, sensitive personal data, added levels of protection are provided, and it's more restrictive. The requirements around the processing of such personal data, sensitive personal data, is more, or those requirements are more restrictive. So you need to classify your data and supply that information to the data commissioner, and then you also need to identify the risks to the personal data or sensitive personal data that you process. The identified risks. So it could be hacking, it could be phishing, it could be all sorts of things that could come to bear in the course of processing personal data. And in addition to that, you must also identify the technical and organizational measures that are in place to mitigate against those risks. So at that point, or at that level, you might need to really sit down with your IT people and your systems people and make sure that you have a proper, solid submission. Because these applications can be refused.
Okay.
And obtaining registration from the ODPC, as you mentioned, is a prerequisite for obtaining certain operational licenses. And you don't want your main businesses your main business rather to be hindered because.
Okay, so it is tied to operational licenses that you're getting as well. For example, the digital credit.
Exactly.
Yeah.
So
Okay.
if you don't have, or if you are an ODPC license, or
then
if it's
you can't
refused,
get,
then how would you then proceed?
Yeah.
So it's that interconnectivity, gives added seriousness or gravity to this.
Gravity to it, correct? Yeah. So we now can say people can get registered, or they will get registered eventually once their applications are considered.
Mm-hmm.
What practical effect will we see on a day-to-day basis interacting with businesses, as to their protection of our data when it is processed or controlled by them? What will we see?
The whole point of this process is to give the commissioner or the regulator visibility on people's operations with respect to personal data. The mere fact that you have someone watching over you, and not just someone who's standing, aloof or, not really bothered about what you're doing, but someone who's gaining a practical understanding of what your security mechanisms are, and someone who's approved them and given you a license. The mere fact that framework exists gives some incentive to all players to manage their personal data in a particular way and to a particular level standard. So you can be, there are lots of people, I would say, who already have these systems in place. Banks already have confidentiality obligations and security obligations, under their own regulator, and they've been doing this. So there's sectoral requirements for different sectors that have been implemented already, but now we're having a cross-cutting standard, a uniform standard, that says this is the bar, you can't operate below it, otherwise we will not license you. And if you proceed to process personal data without our registration, of course it's an offense. 10 years, up to 10 years in prison, up to 3 million shillings in fines. So there's an added security by knowing that people now have a sense of accountability to a government regulator that is very switched on.
Yeah.
Right? And a government regulator that is eager to demonstrate its value and what they're bringing to the table.
It has been in the press, and it has been published, advertised over a period of a year.
Stakeholder engagement has been quite high, and the data commissioner has not been sitting back and just looking. You know what I mean? She's been very, very engaged. And that is something that I believe will incentivize stakeholders to up the levels of security that they accord to the personal data that they process. And so we can have that added confidence. And it gives confidence to foreign international players and stakeholders, multinationals in the digital space. As far as Kenya is concerned, if you think of Kenya as a data center or a data hub, right? People would be inclined to set up data centers here and back up their data in Kenya because there are adequate legislative frameworks and practical frameworks for ensuring security of personal data. Under the GDPR, the transfer of personal data to foreign jurisdictions is regulated, and there are certain jurisdictions that certain supervising authorities in the European jurisdictions have given sort of an endorsement as jurisdictions that have met the adequacy threshold. Right? So they have laws in place, and they have systems and infrastructures that gives European citizens the assurance that if our data is being transferred there, right, it's safe. And this has been certified by the supervising authority. So if we want to position ourselves in East Africa and keep on singing and harping about how we're the internet hub or technology hub in East Africa, we need to ensure that not only do we have the technology, we have the laws to back it up.
What I was talking about is more businesses overtly seeking consent from the people that they're controlling data of or processing data of, so that people are aware of how their data is being used on a day-to-day basis.
Right. I mean, that is an obligation that arose from the Act itself. Even prior to the implementation or the coming into effect of these regulations. So the requirement to have a legal ground, a legal basis for processing personal data is one that arose in 2019. You need to either have consent, or you need to be processing personal data on the basis of necessity for certain reasons, including performance of a contractual obligation or a legal obligation, or entry into such a contract, or legitimate interest, right? So it's either or. It's not a requirement to have both grounds, but you can have one or the other for purposes of processing personal data. So it's not, consent is not a magic bullet, it's not a silver bullet or whatever it is. It's not one trick solves everything kind of prospect. It's an option. It's a good option to have, but it's one, if you rely on consent as a basis for processing personal data, you need to be continually aware of the limitations. It can be withdrawn, for example.
Correct.
At which point in time, you should not proceed.
And you should know how to withdraw it if consent is given, and then later.
I mean, think about it. Yeah. If your business relies on the fact that you handle, the personal data of your customers. So perhaps you are a digital lender, and you have accounts, for your customers, and half of, and you rely purely on consent to process personal data, and half of them say, you no longer have my consent to do this. If that was the only ground you're relying on, then your business sort of comes to a halt.
Correct.
But thankfully, the law has other options. You may be able to carry out some of these processing activities on the basis of other grounds. Or if, as an employer, for example, your employee withdraws their consent to your processing of their personal data. I mean, you have a legal obligation, for example, to keep a record regarding their sex, their name and all that, the details that should go into an employment contract.
So what are the grounds for claiming to need to process and control personal data? You've indicated necessity.
Yeah, so the necessity is broken down into a couple of sub-categories. So it's necessity, for example, for performing your obligations under a contract, performing legal obligations. From a public sector perspective, if you're a public body and you're offering a public service, then you may rely on the necessity of processing for dispensing that service to people. Legitimate interest is something I mentioned before as a ground. It's borrowed from the GDPR as well. And basically, if you as a business operator have an interest that is lawful and for which processing of personal data is necessary, right? And lastly, if the processing that is necessary to serve this legitimate interest is not one that would infringe on the rights and freedoms of the data subject, then you may proceed to rely on the necessity for that legitimate interest. Okay. A lot of people rely on that. So in case someone withdraws their consent, but you have a legitimate interest, right? It's still in the course of the proper lawful functioning of your operations, then you may proceed on that basis. Yeah. But again, the focus, the right holder, the data subject is the most important person. They need to be notified about everything. Yeah. There needs to be transparency in how you handle the personal data. There can be no lack of clarity, no gray areas. Proper notice has to be given for you to be able to rely on these grounds.
Yeah. Okay, so we're now in, I guess, August 2022. Let's talk about August 2023. What do you expect to see that has changed in the space? What do you expect will be the culmination of the bringing into force of all of this regulation, and how will it impact on our companies, the companies that we work with, and businesses in general?
Right. The approach we've taken towards enforcement in this space has been one that is more consultative and cooperative as opposed to wielding a big stick in instances of non-compliance. And I commend the Data Commissioner for that because, like I said, the concept is new to a lot of people. So lots of stakeholder engagement, lots of training and awareness initiatives are happening. But I don't foresee that this will keep on happening or keep on going forever.
At some point, you just need to comply, right?
At some point, I expect the Data Commissioner to begin to enforce and say, hey, listen, as of this date, we're going to start doing audits. And they have the power to do inspections and audits and all that. So I can't say with certainty, I don't have a crystal ball and say that in a year from now, this is what will be happening. But I do expect that gradually we'll begin to see more and more tighter regulation, or implementation of the regulation by the Data Commissioner. I think we'll begin to see more and more complaints, and we're beginning to see this already being lodged now that the framework is in place in all sorts of contexts. An interesting context will be the employment one, right? Where people would perhaps seek redress side by side with employment
with an unfair dismissal claim or a constructive dismissal claim.
Exactly. They'll probably look to the Data Commissioner to say, hey, listen, in the manner in which my my personal data was handled was not legitimate in the course of my dismissal.
Yeah.
Interesting questions might arise regarding publications about whether this person, about an employee no longer being with an organization.
And how that information was shared.
Exactly, and how that was published and all that, whether there was a lawful basis for such
Yeah,
process.
yeah.
And I imagine employment lawyers will be very busy from a data protection perspective.
Okay.
And we're already engaging with stakeholders, the FKE and people like those,
Yeah.
to discuss these issues. But I do see data protection creeping into the employment space a bit more within the next year. I do see an increase in complaints within a year, and after a year, I expect to see the data commissioner being a bit more firmer,
Okay.
with the approach towards enforcement.
And so, from an advisory perspective, for employment agreements, what would you advise that employers do in terms of ensuring that they're in compliance, or at least seeking the consent of employees at the beginning for the sharing of information? So is it a clause in the employment agreement that needs to be added on data protection? What is it?
Absolutely, but even earlier than the employment agreement, we need to have a closer look at how we onboard people, how we seek, the recruitment process, basically, how we seek job applications, how we seek job applications from candidates and all that, how we store their data, even before we onboarded them as employees.
Correct.
Right? Because that's personal data that you're collecting. There's still an obligation to notify them, of certain matters at the point of collection, even before they're onboarded as employees. So you need to review even job adverts, especially the ones that are online. That's the easiest way to provide the privacy notice together with the job advertisement, right? And make sure that people who submit their applications for employment, sort of undertake that they've had a look at this, just to cover yourself, and there's a record, that you didn't just process their personal data.
Are we doing that?
We're doing that, Njeri. I'm in charge. I'm well in charge of that process.
That's very good, because
we at CDH are compliant, fully compliant.
Amen
Let the
to
record
that,
show. But all these considerations are relevant. I don't think people are thinking about them so much, but this is the time to think about such issues. And that's why it's so important to have these sorts of discussions, sort of off the cuff, sort of a bit informal, where, we can discuss these issues in a light-hearted manner and tease them out, but at the same time draw people's attention to it.
Yes, the whole point is to draw attention so that people know where it affects them in their business and in their day-to-day lives, right?
Absolutely. You're doing a wonderful job at it, by the way.
Thank you, Shem.
Yeah, so I think it's something that stakeholders are showing a lot of interest in. Over the past 2 weeks, we've been inundated with inquiries about how to go about this process. We're supporting a lot of our clients in this. It's likely to be an ongoing process over the next couple of months. A few teething problems from a technical perspective with the website and all that, but we're learning, and the data commission is very supportive. They're responding to inquiries and offering solutions.
Great.
So
that's great.
This is definitely something that's going on very well.
So we'll watch this space, but in any case, you're the expert, and I feel very confident in our abilities to protect our clients, and also in our ability to just decipher the information that the ODCP will give us and disseminate it to clients, so that they can have the information and do what they can to comply. But thank you, Shem. It's been an excellent conversation as usual.
Thank you so much.
You are the all hail King Shem.
No. We are all students. We all learning. We learn from each other. It's a new area. Like I said, there are no experts. There is no one who has 10 years experience in data protection. The law is only 2 years old.
I think you're too humble in this. I have it on good information that people are highly reliant on your knowledge of the space. So thank you very much, Shem, for coming to share this information with us. You guys, it's been an excellent education. Shem, thank you so much, and see you next month.